Okay, let me get here. Let me get my thing set up properly. There we go. Okay. Good morning or good evening, Shelley.
Good evening, Everton. How are you?
I'm not too bad. Welcome. Let
Good.
me see if everybody's hearing you. Let me make sure that is the case. Well, yes, I think they can hear you now. Yes.
Okay.
Good evening again, and welcome to A Moment in Time. How are you this morning?
I'm doing well, thank you.
Great. Hey, Shelley, I've invited you here tonight to talk with us about wills and trusts. So, before we go there, though, would you like to tell us a little bit about yourself? What is your claim to fame? What's special about Shelley?
Everything, my goodness. I mean, what a question, right? Well, I I guess by way of just explaining who I am Jamaican born.
Mhm.
I've been living in the United States since 1979.
Mm.
So more time living here than in Jamaica, but I still very heavily identify with my Jamaican roots.
Mhm.
I am married with three adult children and two grandchildren.
Wow. You have beat me there.
I have you beat there, right?
Yes.
Um, I am. I grew up in the state of New Jersey,
Mhm.
although I currently live in Florida. But I lived in Illinois for a very long time, and my children are actually I would consider them Midwesterners, quite
Okay.
frankly, because two of them still live there.
Okay.
Um, yeah, yeah. And I went to college and law school in New Jersey. So I went to New Jersey, college in New Jersey.
Okay.
Um,
So
yeah.
what do you specialize? What law did you specialize when you went to Seton Hall?
Well, for the most part, I just kind of did a general line of study.
Hmm.
Because, when a lot of times you go into this profession and go into law school thinking you're going to save the world, and you actually you go in thinking you're going to do one of those sexy law practices, criminal
Mm.
law. When I was coming up, LA law was the thing, right? That was the
Mm.
show that everybody watched, and I wanted to be one of those LA lawyers. Um, and I sort of fell into estate planning, and it's trust and estate planning. And it's not an area of the law that's very popular,
Mm.
but it actually is with young people, right? But what I would say, it is one of the areas of the law that touches just about every other area of the law. And it's one of those things where even if you're not super wealthy, it everybody, at on some level should have some type of
Estate
estate plan.
planning. All right. Okay.
Hmm.
Hold a second. Guys listening online, you may ask your questions. You can type the questions, and we will translate them for Shelley for her to answer them for you. So here's a question from me. What is a will?
Well, a will is a legal document that basically describes how you want your assets to be devised or distributed at your death, right? And it is used also for multiple purposes. One would be to name an executor who you want to take care of your estate when you go. If you have minor children, you would in your will, name the person that you want to be your children's guardian. Generally, if you're married, it would be your spouse or the child's other parent. But if the second parent is not in the picture, you want to have a say as to who you would want to raise your kids.
Mm.
Because if you don't, guess what? The courts will. And your worst choice is better than the court's best choice, for somebody to,
Is that
choosing
what
a
they call?
person.
Is that what they call probate?
Well, yes. So when you probate a will, it's actually the court validating, saying, yeah, this document is valid, and you're able to transfer title. This person is authorized to transfer, to facilitate the transfer of title from the estate to the beneficiary.
Okay, so wills are important, but I've been hearing about this thing called a trust. Why is a trust necessary? What is a trust?
So the trust is, again, a legal entity, right? And it is, uh, a vehicle whereby you have a trustee who has a fiduciary duty. They own the trust assets. The trust assets are held in this trust, in this entity, and the trustee is basically in charge of these assets for the benefit of the beneficiaries. Um, and so a lot of people have trusts for a myriad of reasons. One is, um, the trustee, well, all right, so the trustee holds title to the trust asset.
Hmm.
And there are different types of trust, right?
Okay,
The purpose of a trust is generally one of the main reasons that people have trust is to avoid probate.
okay.
Um,
Hold on. So let's see if we can simplify this a little bit.
mhm.
So if you have a will, you have to go to the court if you pass away for your beneficiaries to get approval that this will is valid and you can distribute the assets through your executor to your beneficiaries, correct?
Right, that's correct.
Okay,
But let me just clarify one thing.
go ahead.
The will, um, if you the will is used for assets that are held in your individual name only,
Oh,
right? So
oh, I see.
so in other words, if Everton has title to, I don't know, a bank account, a brokerage account,
Hmm.
right? That is an asset that would go through probate. Now, if that same bank account is in trust title,
Hmm.
right? So it's, Everton as trustee of the Everton Walters Trust, um, then that particular asset does not have to go through probate because it's not in your individual name.
Oh.
The same is true if you have a jointly held asset. It's not a probatable asset. So if you have, for example, you and your beautiful wife have a bank account,
Hmm.
and it's, Everton and Terry, um, then, as with rights of survivorship or by the entirety, when one or the other of you passes away, it automatically goes to the survivor. So it doesn't have to go through the probate process, right? It
Okay.
passes by contract.
So, what's the big disadvantage in going through probate? Is that a tax consequence or something else?
No, it's not. It's so, and I actually am, an advocate for probating assets. There are
Mm.
people who don't like to probate assets, but because it's a court proceeding. You generally have to hire an attorney to help you through it.
Hmm.
So there's money involved, and people would prefer not to have to spend money. And it's also time consuming. Now,
Mm.
the 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 one of the advantages of of going through the probate process is this:
Hmm.
in Illinois, um, when you go through probate in Illinois, a creditor has 6 months to come forward and make a claim. Right?
Mm.
There are certain things that have to happen. Like, there has to be published the um, there has to be publishing, and they have to, be aware that the person has passed away. But that's detail that you would work out with your attorney. Um,
Mm.
the so a creditor has 6 months to come forward during the probate process.
Okay.
At the end of the 6 months, if they haven't brought forth a claim within that time period, they are barred from bringing a claim after that.
Mm. I see.
Um, so the advantage is also the disadvantage, right? So you're having to wait a 6 month period to make sure there are no claims brought. Um, but after the 6 months, you're pretty free and clear. Now, if you don't go through the probate process, the creditors have 2 years
Wow.
in which they can come after you.
Is that the
So,
same right across all the states, or it differ for different states?
um, different states. So, for example, as I mentioned before, I now live in Florida. Florida, the creditor period is 3 months, but
Wow.
the 2 year period is for the most part across the board.
Okay, I see. Now, I know a lot of people have a trust and a will.
Hmm.
Is that typical?
It is very typical. Um, and, generally, people will use the will to devise like tangible personal property. So, in other words, they might use it to distribute jewelry, or they might use it for specific bequests. You Everton have a good friend named Shelley, and you want to give her, at your demise, you want to give her $50,000.
You're so kind.
Then you can do that in your will. The will is a public document, though.
Okay, okay.
So you have to file it within 30 days of death in Illinois.
Hold on, hold on,
Um,
hold on. The will is a
mhm,
public document. When does it
yes,
become public?
when you die and it gets filed with the court.
Oh, I didn't know that.
Yeah.
All right. Is
Now,
it?
a trust is not a public document,
Oh,
so
that's
that's why a lot of
interesting.
people a lot of people have the trust, so that they have that privacy.
Mm, mm.
Right? So anything you can dispose of assets in your trust just as you could with your will. So what a lot of people do is have what they call a pour over will.
Hmm.
So basically it's you know generally like a 2 or 3 page document, and it says, all the rest and residue of my estate pours into my trust.
Mm.
And the trust is where you make all um, your dispositive provisions. So that's where you can make your specific bequests. Your residue at that point will be, you've got your children, 50% here, 50% there, or whatever, charities, whoever you want to benefit. You could do that in your trust.
Okay. Can you therefore use a trust to operate before you die? Or is it only after you die the trust works?
No, you can have a trust while you're alive. most many people do. Um, and it helps with managing assets. Um, it doesn't necessarily, unless so you have two types of trust. You can have a revocable trust
Mm.
where you, as the testator or the grantor of the trust, you're free to make changes to the trust, um, change beneficiaries, change the terms of the trust, whatever. And then you have irrevocable trusts. With the irrevocable trust, it offers you more asset protection in that once you put an asset in an irrevocable trust, it no longer really belongs to you. It's out of your estate, so creditors can't really get to it. With a revocable trust, though, it's still considered yours, so they could conceivably, get to those assets. But it's a good tool for asset management, like I said. It's a good tool for, um, uh, you have a trustee, so if something should happen to you, you could, if you're the initial trustee, you could name a successor, and if something were to happen to you, some kind of incapacity or disability, you have a trustee there who could succeed you and continue to carry out the terms of the trust. So, continue to give you income, continue to make whatever distributions, or whatever, carry out the terms of the trust.
So
So,
the trust can survive you and continue to operate even after you have passed away.
absolutely, yeah.
But that only applies to the revocable one or the irrevocable one. Both can.
So both can. So once you die, the revocable trust becomes irrevocable.
Oh, I see.
And yeah, and generally, the terms of the dispositive terms of the trust come into effect once you pass away. You know, you're gonna either create continuing trusts, or you're gonna distribute my assets outright to whomever, to your kids, to your spouse. Um,
And therefore,
generally,
and in that case, you can determine how the funds are distributed to the individuals,
that's right.
and under
So you
what.
could create a continuing trust. Let's just say, for argument's sake, you have a child that you're concerned about making good financial decisions or whatever, and you could create a trust um, resulting from your existing trust, right? So when you die, it
Mhm.
creates another trust for the benefit of that child and or children. And the terms of the trust would say, this child is entitled to health uh, um, distributions for um,
So,
health maintenance, whatever, um, and they can get X percentage of the trust at age 40. And
mm,
then hopefully by the time they get to age 60, they'll be a little bit more fiscally responsible, and then they can get the rest of it at that time or whatever. So you can create trusts to continue beyond um, you know,
your death, but a
yeah.
will couldn't do that, right?
Well, the will itself couldn't, but you could create trusts under the will.
Okay,
So
I
the
see.
so the trust could so the will could create a trust. Yeah,
Okay,
those are called testamentary
okay,
trusts.
all right.
Hmm.
Now I know that it is rather expensive to set up a trust, but it's not that expensive to do a will, correct?
Right, right. So at the very least, you should have a will,
Hmm.
because regardless of and I think I think I said this initially, regardless of, whether you think you have enough assets or not, you want to be able, you've spent your life amassing, your wealth, right?
Mhm.
You have your house, you have your bank account, you have your this, your that, your stamp collection, right? You
Mm.
have your believe me, I've seen this seashell collection that actually is worth that was very valuable. You want to be able to
Seashells?
seashells, yeah.
Really? I need to collect
Yes.
some seashells then.
You need to collect some seashells. Um, and you want to be able to say who gets that,
Okay.
right? Who's going to treasure it? Who do you think you want to receive that? And again, if you have minor children, you want to have a say in who helps take care of these children. You can name one person to be the guardian of the person, and one person to be, and another person to be, like their financial guardian.
Mm.
um, you, you, so there are a myriad of reasons why you would, because trust me, not planning is actually planning, because the state will determine
Mm.
who gets what.
Oh, a question that came in is, what is the major disadvantage of a trust?
The major disadvantage of a trust, from well, like you said, it may be expensive to get set up. I mean, because
Hmm.
you are incurring attorney's fees and things like that, which you would anyway with a will, but
Hmm.
with a trust, it might be a little bit, a little bit more. Um, if it's a simple grantor trust, there is not, the filing of income taxes and stuff like that would all be reflected on your personal income tax return. Um, it depends on the complexity of the trust. Some trusts require their own tax ID and require their own, um, you know, uh, income tax return, a fiduciary return, a 1041.
Hmm.
Um, and I would say the major disadvantage is creating the trust and not funding it.
Oh, that's another
Because,
question. Yes.
yeah.
So, so once a trust is created, it has to be
Mhm.
funded, but a
Right.
will don't have to be funded, right?
No, because the will, any asset that you own in your individual name
Hmm.
will um, will be dealt with, so to speak, under your will.
Okay.
If you don't retitle the assets, it
Mhm.
is going to be a probate asset,
Okay, so
right?
let's say that you have gone through the legal paperwork and set up the trust, register the trust, send it into the state as a document that you send to the state of the city hall or whatever you send it to. Do you have to do that, or you just keep it in your drawer,
No, you can just keep it in your drawer. You don't have to. You don't necessarily have to file a trust with anybody,
even if it's
because
revocable?
again,
Even if
even
it's
yeah, it's revocable. Now, uh, if you are creating something other than a trust, so let's say for asset protection, like an LLC or something like that, then yeah, those do have to be filed. But just creating a trust, you don't have to file that with anybody.
But you mentioned funding the trust. So
Mm-hmm.
now that you have formed the trust, and some may need to have their own EIN number, but
Mm-hmm.
regardless, or sometimes you use your own social security number. Now,
Right.
how do you fund the trust? What does it mean to fund a trust?
So what it means is you need to retitle everything in the name of the trust. So that brokerage account that you have is no
Mm.
longer Everton Walters. It is Everton Walters as trustee of the Everton Walters Trust.
Okay. So
That
everything you have, your bank accounts have now got to change from your name to the name
into
of
the
the
name of the
trust.
trust. That's
And the
correct.
and the trust don't necessarily have to have your name in it, does it?
No, it doesn't.
Okay.
It doesn't.
So you can call it Tom Jones Trust if you want to,
You
as
could,
long as you know
you
what it
could,
is.
they're right. So a lot of people, yeah, protect their privacy that way. You call it whatever you want to call it.
Okay. So now that you have this trust set up, to title the things in your name, in the trust, sorry, you have to go to the tax office to transfer the car into the trust name, or do you have
Yeah, well,
to?
I mean, you have to do whatever. Yeah, so you would be going to the Department of Motor Vehicles to get that transfer. Now, although I would say that um, a car I probably would not necessarily put in trust title,
Okay.
um, just because of liability, right? But uh, but yes, whatever it is that you whatever your if your home,
Hmm.
if you're going to, that has to be recorded. The deed has to be recorded, trustee deed.
Hmm.
Um,
So,
um,
so hold on. So, if the trust is not funded, what happens to it? It just dies.
it just dies. It's unfunded and it just dies. Now, if you have a pour over will,
Hmm.
um, and your assets remain in your name, so what's going to happen is they're going to go through the probate process
Let me
and the
stop for a
will.
while. Let me stop for a while. I just want to advise you guys here that we are not giving legal advice here. We are having a
That's right.
discussion. And if
That's
you
right.
need to have a legal advice, please consult your attorney or your accountant or somebody who can give you some legal advice. So don't call me for any legal advice here. We're just giving,
100%. I'm so glad that you said that, Everton. Absolutely.
just want to
Yes.
make sure that's
This
clear.
is yes, this is not legal advice. It really is just a discussion.
Okay.
Um and pretend you don't know anything about my background. This We're just talking here.
Okay.
Um
Okay. So that being
um
said, you were saying earlier, you
oh
continuously bit.
so the your assets would be in your individual name. It will go through the probate process. If your will says, if your will is a pour over will and it says pour into the trust, then at that point your trust would get funded,
I see.
right?
I
With
see.
Because the assets then pour into the trust, and then the terms of the trust would dictate what happens next. So the dispositive provisions at that point of the trust would kick into kick into gear, and that is, that would, the trust would say everything goes to goes to my wife, either outright or in trust, or 50% to my wife and whatever to my kids, whatever the terms of the trust are.
There's another question here. At what net worth should you consider a trust?
um you know that actually is a very good question, and it is it depends on the purpose, I would say, of your trust, of why you would want to create a trust. And it's a conversation that you should have with your attorney. If you have a very modest estate, I don't think a trust is necessary.
Hmm.
Um,
When you say,
if however you are in a ah if you are in a profession that is has a potential for liability, so doctor, lawyer, Indian chief, that kind of thing,
Hmm.
um, then I would strongly advise going through the probate process. So you cut off claims after the 6 months,
Hmm. Or whatever
um,
period is in the state you're
or
in.
whatever period is for whatever state you're living in. Um, and and if you have sufficient assets, I would probably say yes. Also, a trust, just for privacy. As you make your will wouldn't necessarily dispose of the assets. You would dispose of your assets in the trust. But again, if your estate is modest, why bother? But
Are
I
there,
but
are
but
there
having go
are
ahead.
there tax implications for trust as against wills? Again,
Um,
hold on before you, because this is very tricky. So, guys, again, this is not legal. This is just a discussion. So, just give your opinion on this.
right. This is not legal, nor is it accounting advice. Um, so there is not. It depends. It
So
depends.
let's leave it at that.
Yeah.
So if there are tax benefits or advantages for your trusts, I'm being very careful here because we don't want to get in trouble.
Right.
It's best to just consult your attorney or your accountant in setting up a trust. I recommend strongly that if you're going to think about doing a trust, that you consult a trust attorney, and there are several located all over the country. All right. So find somebody who deals with trust and go and have a consultation with them. Typically, they don't charge for the first consultation, right, Shelley?
That's correct. And I would, to Everton's point, go to someone who specializes in trust and estates, because there are a lot of pitfalls and the laws change.
From state to
c-
state,
uh,
or
Big uh, tax situation in 2020, at the end of 2025. Nobody
mm,
quite knows what's going to happen after that in an estate tax situation. So there's a lot of planning that can go into um, making sure that you're not adversely affected tax wise. So make sure that if you're going to do this, that you consult with an estate trust and estate um, attorney.
wow, Shelley, we could talk all night, but our time has actually expired and realized that we have spent, oh my, oh my, oh my. Well, thank you so very much. I know we could talk about a number of other things that I have
Yeah.
concerns about. But it is a start of a discussion, folks. And just make yourselves acquainted with the law and get an attorney to deal with the issues for you so that you know what to expect and what to do in your personal situation. Right?
And just one more thing I would love to add here. I know we're talking about wills and trusts, but in your estate, while you're looking at your estate plan, also think about power of attorney for healthcare, power of attorney for finances, and look at a living will as well. Those are all documents that you want to consider.
Oh, a living will. That's interesting. We'd love to talk more about that, but we don't have much more time. So, Shelley,
Right.
I just want to say thanks a whole lot for the valuable time that you have given us. I know you're tired and you've worked a long day today.
I did. This is well past my bedtime, but it's okay. I'm happy to do it.
Thanks for sharing with us and have yourself a really great night. All right,
Thanks.
sis.
You too.
Bye
Thank
for
you.
now.
All right. Take care. Bye bye.
Well, folks, there you had it. Let me get back out of this. Hope that was helpful for you. I thought Shelley did an awesome job of explaining the process. And it has been a pleasure talking with her. And I hope that you were inspired by this. Well, we have come to the throne room. And I like this transition actually because it is so often that we do not spend time preparing our future, right? And there is another dimension to your future that you need to prepare for, and that's your spiritual future. We talked about your financial future just now in terms of what you're going to do for your wealth management. And coming up in a couple weeks, I think on the 13th, the week following the election, we will be talking about how to start a company, whether it's going to be an LLC or an incorporation. What's the difference between a C Corp and an S Corp, and how you can manage that type of thing, as well as we look at what will be necessary or should you start a 501c for your charitable deductions or your charitable contributions? Should you start one for yourself? So we will look at all of that in a couple weeks. On the 13th, we will be talking to you about that. And we'll have another guest with us. He's another attorney. His name is Marcus May, and he will be joining us on the 13th to talk about that. But here comes Sunday. This is the throne room.
A great light dawns in Galilee. Some say madman, some say king. One.
I think the echo is off now. I think I had a double signal coming out, so hopefully
Jesus
this helps.
Christ the Nazarene.